All right, got a couple of legal updates for you this week in the lead up to the coronation, which is tomorrow. We've got an update on Samantha Markle's defamation case against Meghan, and we've got a brand new case filed by the Heritage Foundation against the US Department of Homeland Security. So they are suing the government for not granting them access to the information they requested about Harry's visa application. As usual, I will be placing all related prior videos on these topics in the description box, and especially when it comes to Samantha's defamation case, if you don't know what's going on, I do highly recommend you check out these videos because it's a long story and, I don't want to keep repeating myself. So, without any further ado, where do we start? Which case do we start with? I think we'll start off in chronological order. So that means defamation case is up first. I want to start off with a very important point. This is entirely crucial to the success of Samantha Markle's defamation case if it doesn't get dismissed, because what we're looking at today is Meghan's motion to dismiss. I've mentioned in previous videos, and this may sound familiar to you, the additional defamation element of actual malice. This is an additional element observed by some jurisdictions when it comes to plaintiffs who are considered public figures. Now, in this case, there is no dispute about whether Samantha qualifies as a public figure. Both parties are in agreement that she indeed is. Meaning, this additional element, which is notoriously difficult to prove, does apply. Strictly in a legal sense, actual malice doesn't mean malice or ill will. It simply means that the defendant made their allegedly defamatory statements either knowing that they were false or they couldn't care less if it was true or false. A reckless disregard for the truth or falsity. Now, I will say from my experience, actual malice is usually a question for the fact finder, being the jury in this instance, to decide upon whether it was present as an element or not. So on the face of it, if it looks like Samantha has a case, enough for it to go to trial, then it is likely that the judge will let it proceed to trial and will rule that actual malice is a matter for the jury to find, not Meghan's lawyers. All right, now that that's out of the way, let's have a quick look at what Meghan's team has come back with. In the last video on this topic, we went through the third iteration of Samantha's complaint, in which they took the judge's hint in her initial dismissal judgment and revamped the way that they tackled this case by alleging defamation by implication, rather than simply defamation per se, which is when you sue someone for what they expressly stated. Now, Meghan's team have come back with yet another motion to dismiss, basically arguing that nothing has changed in this new complaint in relation to the Oprah Winfrey statements in particular, and as such, the judge should go ahead and dismiss the case as it did last time, except this time with prejudice, so permanently. They also argued that the new Netflix statements don't fly. They're just not defamatory. Speaking of these additional Netflix statements, by the way, when I read through Samantha's third complaint last time, I didn't know that she didn't seek leave from the court to add these additional claims. And if Meghan's team is to be believed, it looks like that's what actually happened. Now, I'm an Australian lawyer, so I can't speak for Florida's civil procedure rules, but in Australia, if you want to amend a complaint, an originating process, you do have to seek leave from the court to do so, unless there are, a few exceptions that apply, in which case you can seek leave from the registrar instead. But if it's true that Samantha's team didn't seek leave before adding these additional statements, it will be interesting to see what Judge Honeywell has to say about that in her next judgment, because what Meghan's team want is for, number one, the claims to be dismissed entirely, but number two, they're also arguing that these new statements need to be stricken out of the record because they exceeded the scope of the original complaint. And if you do read the judge's last order where the case was dismissed, she did give leave for Samantha to revamp her Oprah Winfrey statements arguments, but not necessarily to add any new claims. So this could be problematic for Samantha, but we'll just have to wait and see. Now, for the sake of brevity and simplicity, we won't be getting too bogged down in the technicalities of this motion to dismiss, but I will say that one major aspect that makes Meghan's argument stronger than Samantha's is the fact that her lawyers cite a lot of case law as precedent to back up their arguments, which is a concept that common law is entirely built upon. Now, for those of you who may not be too sure, precedent is basically law that has been set by the decisions of previous courts, usually higher courts, in relation to cases that are similar in nature to the current one that is being tried. So it's like a new standard of law is set to follow. And citing case law can really bolster your case. And on the flip side, a lack of case law or precedent can serve to really diminish the strength of your case, if not destroy it altogether. Secondly, much like they did in their previous motion to dismiss, Meghan's team is arguing that, implication or not, most of Meghan's statements on the Oprah interview are still a matter of her opinion. And as you all know by now, I hope, honest opinion, or opinion in some jurisdictions, is a defense to defamation. They also argue that even if Meghan was implying that her sister was indeed, a fame-hungry, attention-seeking grifter, who wants to profit off of her sister's name, then that too is a matter of Meghan's opinion. That's what Meghan thinks of her sister and what she's doing. And they do cite case law that supports this argument, whether you personally agree with it or not. Previous defamation cases dealing with such accusations or implications have been found to be pure opinion and therefore not actionable. Now, it is a compelling argument because it's backed up by precedent, but I will say that lawyers do tend to cherry pick cases that support them. It's part of their job. So there may actually be case law out there that would bolster Samantha's argument and would argue otherwise, that accusing someone of being fame hungry and publicity seeking is a defamatory statement or could be a defamatory statement. But it's up to Samantha's lawyers to find that case law and cite it to support their argument. Now, other than the defense of opinion, the defense of substantial truth also comes up specifically in relation to statements number 3 and 4. So statement 3 was Meghan's comment about not having seen Samantha physically in a couple of decades. Her lawyers argue that this is true, which is a defense to defamation. It shouldn't matter that, as Samantha argued in her complaint, they spoke on the phone in lieu of meeting in person. Now, as we discussed in the previous video on this topic, Samantha's workaround regarding this specific statement is that the implication arising from it paints Samantha as this stranger to Meghan who barely knows her and who barely had a relationship with her. And that's why Samantha said, well, we spoke on the phone frequently. We had a sisterly relationship. I'm disabled. That's why it was difficult to see each other in person. So she's not alleging defamation per se. She's going after Meghan's implications. Now, unfortunately, I am persuaded personally by Meghan's team's argument in the sense that, implication or not, what she said was true and therefore is not defamatory. But we'll just have to see what Judge Honeywell seems to think on this one. Finally, the name-changing allegation. We discussed in a previous video that while Samantha legally changed her name to Markle in July of 2022, throughout her life, she has interchangeably used her maiden name way before Meghan met Harry. Now, Meghan stated in the Oprah interview that Samantha only changed her name after she had started dating Harry, thereby implying that her sister is a fame-seeking, clout-chasing grifter. Now, Meghan's team is arguing that once again, what Meghan stated is substantially true. And it looks like the court has already been put on notice previously, before the case was dismissed, that this is substantially true because there is evidence that Samantha has used a different surname in September of 2016, only to use Markle as a surname 2 months later after Meghan and Harry's relationship went public. Now, again, this argument from Meghan's team, much like the one prior with the meeting in person argument, is treating it as a defamation per se, in the sense that what Meghan expressly stated was substantially true. But they've already talked about how, even if you want to argue the implication route, it's been found by case law precedent that calling someone a fame-hungry clout chaser is not necessarily defamatory. It's a statement of opinion. So it looks like to me that they've really got Samantha's team cornered, and unless they have a chance to respond to this with additional case law to support their arguments, it's once again not looking too good for Samantha Markle at this point. Now, with the Netflix statements, without going through all of them, because like I said in the last video, there were just far too many to go through one by one. For the most part, Meghan's team's arguments echo the ones that I put forth when I went through Samantha's complaint in the last video, being that most of the claims were either not statements of fact at all, or were simply not even about Samantha to begin with. And please do refer to the previous video called Danger Zone on this topic if you're kind of lost. I want to focus on the argument that I thought last time was the strongest argument in Samantha's favor. Now, this is of course notwithstanding the fact that these may be stricken off entirely if it is indeed true that Samantha never sought leave from the court to add these additional statements. Now, the statement in question is Christopher Bouzy's allegation that Samantha was part of a hate group and was spreading disinformation. Firstly, it is worth pointing out that Meghan is arguing that she didn't publish Christopher Bouzy's statements, they're not hers, and therefore she can't be held liable for what someone else said. But like I said in the last video, Danger Zone, I think that as an executive producer on the show, and she's specifically named, it wasn't just Archewell, it was her name, I think she can indeed be held liable for what has been published in her show that she helped produce. So I'm not sure if this argument's gonna fly, but they do go on further to argue that, okay, even if she is responsible, or even if she has been found to publish these statements, they're not defamatory. Now, they argue that claiming that Samantha is part of a hate group and is disseminating false information or disinformation are both statements that are not capable of being proven to be false, not because they're necessarily true, they're not relying on the defense of substantial truth, but because they have cited previous judicial opinions that have held that these words, like belonging to a hate group and disinformation, are too ambiguous, they're too loose to be proven as either true or false. I will say that based on the wording used in Meghan's motion to dismiss, it does seem that these judicial opinions are just that, opinions, also known as obiter dictum. So just things that judges say in passing as they opine, during their judgment. Not everything that a judge puts down in their judgment is law. You have to find the actual precedent, the actual ratio decidendi that would act as binding case law. And it doesn't look like these opinions made by the judges are binding case law, meaning they don't have to be followed or applied to Samantha's case. So if Samantha has the chance to find case law to argue against this and clearly demonstrate that accusing someone of being part of a hate group and disseminating false information can indeed be defamatory. I mean, if you ask me personally, separate from any case law, I think that a hate group is indeed capable of definition. I don't think it's a loose, ambiguous term. I mean, I can just give it a shot right now. It's a group comprised of people who share a common hatred of someone or something and are motivated to act based on this hatred. And disinformation is basically another word for false information. So I'm not too convinced with Meghan's team's argument on this one. I think that this can still be potentially Samantha's strongest argument in her case. And in terms of actual malice, they would have to prove that Meghan allowed the statement to be published knowing that it's false or having a reckless disregard for its truth or falsity. Now, this one can be tricky because it's Meghan Markle we're talking about. She practically thinks that the whole world is against her, and everyone who doesn't worship her is part of a hate group who means her harm and spreads false information about her. So she may actually think that it's true, which would defeat the actual malice element. And mind you, actual malice is a subjective test in the sense that you look at what the defendant subjectively believed at the time that the statement was made and published. So it could be an uphill battle for Samantha to prove that. But again, the judge might decide, well, this is a matter for the jury to decide upon, not the lawyers. There are other statements that I've pretty much covered in the last video, Danger Zone. And like I said, Meghan's team have come back with very similar arguments. So I'm not going to be going through them again here. And I will say that all in all, it does look like Meghan's team have come back with a stronger argument purely because they've cited a lot of case law. And some of their arguments are compelling, I'm not going to lie. This case, as I've mentioned over a year ago at this point, always had its weaknesses. It's always had its problems. And it's not to say that Samantha doesn't have, the right to stand up for herself and clear her name, which of course she does. And I think that's why it's good that she makes these interviews, because that's a chance for her to put her version of the story out there. But in terms of a court of law, defamation law is incredibly complex and it's incredibly difficult to prove a lot of the time. These cases rarely make it all the way to court. So I don't want you all to think, oh, the judge was just siding with Meghan. No, these are notoriously difficult cases to litigate, and it doesn't reflect badly on Samantha if it gets dismissed once again. Sometimes a court of law is just not the right avenue to deal with these issues. But as always, I could be wrong about a few things, about a number of things. I mean, so far, I would like to say that I haven't been, but things can change and the judge might decide differently. So again, I would urge you to wait for Judge Honeywell's response to all of this to, make a final determination, obviously. Don't just take my word for it. Now, this newest update in the Prince Harry visa application saga actually took me by surprise. I mentioned in the first video that I made on this topic a couple of months ago now, I think it's called The Elitist, that, the Heritage Foundation, or anyone for that matter, who files a Freedom of Information request, which then gets denied or rejected by the government body, does have a chance to appeal that rejection to a court of law. But I was also skeptical about whether the Heritage Foundation would actually go ahead and do that, because obviously it costs a lot of time and money. But guess I was wrong, because that is indeed what they ended up doing. They have now sued the US Department of Homeland Security to gain access to that information. And they're arguing that despite legislation protecting such sensitive information, which we discussed in the last video on this topic, the public interest in knowing how Harry answered the questions on his visa application far outweighs his right to privacy. Now, I'm not too convinced by this argument because it's not just a common law right to privacy we're talking about here. It's clearly stipulated in legislation, which is a much stronger form of law, meaning it's going to be very difficult to argue that the public interest in this matter outweighs a legislative right to privacy. So I'm not holding my breath for this case, but there's always room for surprise. There are apparently 2 drug-related questions that you get asked when filling up an application to enter the United States. One of them is, are you or have you ever been a drug abuser or addict? And have you ever violated or engaged in a conspiracy to violate any law relating to controlled substances? Answering yes on either of these questions can lead to your visa being denied, as was the case, according to reports, with Amy Winehouse. So the Heritage Foundation really wants to know what Harry answered, specifically in relation to these 2 questions. And it gets more interesting. There is apparently a history of the government releasing immigrant documents about public figures, which can be found on the US Citizenship and Immigration Services website. These include the immigration records of celebrities such as George Michael and John Lennon. However, as you may have surmised yourselves, these two men are deceased. Many legal rights are lost upon death, and this includes a person's right to privacy. If it is indeed the case that only the records of deceased people are up there, then of course it would really vastly weaken the Heritage Foundation's position, because you'd be essentially comparing deceased people with the living. Apart from the Freedom of Information request, the Heritage Foundation also wants the government to re-evaluate Harry's current visa status. So to look into it, investigate it. And this is because of his latest admissions of drug use in not only his memoir Spare, but also in various interviews in which he promoted the book, most famously or notoriously, his monetized online therapy session with Dr. Gabor Mate. To be honest with you, I've already said my piece about how realistic it would be to ban or deport people, especially celebrities, based on admissions of drug use, especially if they weren't ever charged with a crime in relation to this drug use. I've heard about people saying, oh no, I know someone who got deported because they used drugs in their own personal capacity. And I know of someone who was denied entry into the country because they used drugs in the past. But like I said, in The Elitist, a different rule book applies to the elite in comparison to the rest of us, where yes, we would be subject to the law and we would get banned or deported or denied entry altogether. But I highly doubt that Prince Harry and the likes of Prince Harry would be subject to the same laws. It is unfair. Obviously, I'm not a proponent of this double standard. It's disgusting, but it's a reality, and one that isn't going anywhere anytime soon. And when you especially consider that it's the Biden administration right now, which I'm not trying to get into politics, I'm not a political person, but Joe Biden is notoriously friendly, or at least has been in the past, with Meghan and Harry in particular. So that just ups the chances of Harry being protected and the Heritage Foundation's case being dismissed. But much like Samantha's defamation case, we will have to wait and see what the powers that be decide. That's it for today. Coronation Day tomorrow. It's, I think, gonna be live around the evening time in Australia, so I will be tuning in. And there are already talks about Harry apparently being a no-show, without telling anyone, to cause drama and stir controversy, and as a big FU to his family. But you know what? I'd say to that? Good riddance.